202 note-taking that is requested by both parties, and that will be given.
Your Honor, regarding 202, the people did modify it. It speaks to a court reporter. We just changed court reporter to court record to comport with the audio record instead of court reporter. So.
Yeah, the way I have written down is the court's recording. Okay, so yeah, it would be changed to court's recording.
That's fine.
Two or three multiple defendants, so that's requested by both parties, so that would be given.
Your Honor, there is an objection to the defense instruction. They split both of these defendants into two separate charges, listing the name of the that they've assigned to the chickens they took. We don't believe that's appropriate. We believe if you read the Caltram, when both defendants are charged with the same crime, that should be indicated as such. The language says both defendants in this case are charged with the same crime. That's what should be given.
It does give the Calcrum instruction does give the option to elaborate and to separate the two defendants as the defense had done, but let me see.
Your Honor, with respect to saying that both defendants are responsible for the theft of both chickens, I think that creates a host of problems. Number one, there was never any notice that either defendant was going to be prosecuted based on an aiding and abetting theory. And second, it creates a huge problem with jury unanimity, because you're essentially building in two separate crimes into one count. And a jury could decide, I mean theoretically at least, that one chicken was rightfully taken and the other wasn't, and we won't know which one, and we won't know which defendant.
And Your Honor,
So it creates a huge problem.
aiding and abetting is a general principle of the law. No notice is required. We are requesting later on in instructions aiding and abetting principle. We think the evidence is very, very clear that that should be given, in that there was testimony as to this being planned. They had decided to do it, and they both worked together. The video showed them working together in that sense. So I believe counsel's statement is correct. Both could be guilty for either chicken, and if the jury determines that one was taken wrongfully and the other there's questions about, they can still find the defendant guilty. That said, in terms of this particular instruction, saying that one defendant took a chicken now known as Ethan, the self-serving name they've assigned to a chicken they took, and then one chicken now known as Jax, a self-serving name that they assigned to a chicken they took, creates a numerous host of issues, and it should be given in line with the Calcrum instruction. Now, both defendants in this case are charged with the same crime, is what we're suggesting. Defendant Alicia is charged with petty theft. Defendant Alexandra Paul is charged with petty theft. That would be the other way to word that. The reason I said both are charged with the same crime is that shows redundancy, and that would be a correct statement, though.
I think if we handle it that way, Your Honor, we're inviting a host of problems, including an ambiguous verdict. And if the verdict is ambiguous, then that would result in a necessary acquittal. I've had that happen before, actually. So I think we really need to nail down who's responsible for what and under what theory, because if we just submit to the jury that both defendants are being charged with stealing both chickens, I think that creates a huge potential problem.
Well, Your Honor, I would disagree. Aiding and abetting, like I said, is a general principle of the law. And it's something, the court stated, so is value, for example, in terms of petty theft. It's a general principle of the law. To say that it creates an issue now is, quite frankly, unfounded when we have a tremendous amount of evidence that shows these defendants acting together in concert with the same goals and the same general actions and the same apparent intentions based off the videos and their own statements. For all those reasons, aiding and abetting is an absolute proper theory on which the jury could find guilt of either defendant for the theft of either chicken, given that they were acting together.
The other issue with the name is that I think these names were given by the defense after the fact, right? They're not.
Right, but,
So,
and I'm not aware of any other way to distinguish the two.
well,
And the other problem is that if we don't nail down which defendant is being charged with what wrongful acts, how do we know that all of the jurors are unanimously deciding that they committed the same wrongful act?
Well, the unanimity instruction spells that out pretty clearly about what the agreement is. We're getting ahead of ourselves in terms of this, but I believe it's valid to discuss this now. We can't just throw out a valid legal theory for those reasons.
well, here's the court's suggestion. Defendant Alicia Santurio is charged with petty theft of a chicken, period. Defendant Alexandra Paul is charged with petty theft of a chicken, period. Just leave out the names. All right, so that's the decision of the court.
We just make our objection pursuant to Ms. Santurio's state and federal due process rights and
Yeah.
right to a fair and impartial jury.
Okay, objection to it.
Thank you.
Your Honor, I'm just joining that for the record.
Okay.
Thank you.
All right, 207, who be not shown actual date, that's fairly standard, we'll go ahead and grant that one. 220, reasonable doubt, that is granted, requested by both sides. 222, evidence, that is requested by both sides, that be granted.
Your Honor, that would need to be modified to indicate the court's reporting instead of the court reporters.
Yes. Okay,
That's fine.
I'll make a note of that.
And our proposed instructions modified.
Yes. Two 23, direct and circumstantial evidence. Okay, that is requested by both sides, that be granted. 224, circumstantial evidence is sufficiency of evidence, that be granted. 225, circumstantial evidence, intent or mental state, requested by both sides, that be granted. 226, witnesses.
Your Honor, with regard to 226, two of the bracketed options we removed. I noticed they're in defense as proposed. Number one, has the witness been convicted of a felony? I don't believe that's at issue here.
I
Also,
agree.
the last one was the witness promised any benefits in exchange for testimony? None of that had actually come out in the evidence. I don't think either one of those brackets should be given.
Yes, court agrees with that.
Thank you, I submit it.
Two 251, union of act and intent, specific intent or mental state. Okay, that is part of the crime, that'll be part of the nature of this crime, so that'll be granted. 300, all available evidence, requested both sides, that'll be granted. 301, single witness testimony, that'll be granted. 302, evaluating conflict in the evidence, that'll be granted. 303, limited purpose evidence in general, that'll be granted, requested by both sides. 304, multiple defense, limited admissibility.
Your Honor, I'm not requesting this instruction. It's
Yeah.
included in my packet just because the defense included it and I was mirroring that. But I'm not aware of any evidence that would only be admissible as to one defendant over the other based off of the trial that I heard. So if there's something I'm missing, maybe we can discuss it, but I don't think this instruction should be given.
I don't recall either, counsel.
I tend to agree, Your Honor.
Okay.
I don't think we need 304.
Okay, 304 is excluded.
Your Honor, moving on to 306 next. The people are objecting to 306.
Okay,
This instruction is generally not a proper instruction to give in most matters. It's given sometimes as a sanction. The court's already, no, we disagree with the court's ruling that there was any untimely disclosure of evidence, and we need to argue that a little further. But even to the extent there was, the court prohibited the witness in the people's case in chief. And it was disclosed to defense counsel some time ago, almost 2 weeks ago, right after we got it, it was disclosed. And in any event, that should not be an instruction that was given. It would serve only to prejudice the jury against the people. Now, I buttress this with the backdrop of several sustained objections throughout the course of this trial when defense counsel tried to ask about bias or prejudice of the district attorney. This just delves further into an impermissible consideration for the jury. At this time, it is not necessary. It is not one that should be given.
okay.
Your Honor, in response, the court did exclude Mr. Sutton from the people's case in chief based on an untimely disclosure. And notwithstanding that order, Mr. Sutton was allowed to testify. And in fact, the people actually got a windfall because he got to testify at the end of the case, get the last word. And so we think that it's important that the jury know that there was a reason why Mr. Sutton didn't testify in the case in chief, and it was because of a discovery violation.
So,
You know, I would just add that our expert was noticed on February 3rd. We gave them dozens and dozens of documents in expert discovery, a necropsy that they had in their hands for more than a month and a half before the conclusion of the trial. So many documents, and to this date, I think the only responsive document beyond a police report and audio recording that were disclosed at the very last minute was one sheet from Foster Farms related to this expert. Now, the expert testified and we were able to rebut them, but our notice for what evidence we would be rebutting was literally 5 minutes. So I think that is prejudice. I don't know what else would be prejudice, if not that. And I think that the jury's entitled to hear that when there has been a discovery violation and when our expert has been given essentially 5 minutes or whatever the amount of time was, 10 minutes notice to try and respond. I think she did a pretty good job, but still, the jury's entitled to know that we didn't know anything about this and we had no documents compared to all the discovery we gave you and our expert until the very last minute.
Your Honor, this instruction reads, an attorney for the people failed to disclose the testimony of witness Mr. Sutton in a timely fashion. Here's why that is extremely problematic. That did not occur. Mr. Sutton, number one, is not an expert witness. Mr. Sutton was a witness directly as to the business dealings of Foster Farms, the company for which he worked. He wasn't talking as an expert evaluating other pieces of evidence. Number two, and most importantly, the people, as the case progressed, the people sought out Mr. Sutton, found out who he was, obtained the information, and provided it immediately. That's what the law requires, is that there's nothing in the law that says we have to know of a witness that we're going to call, or we can't then later find a witness and somehow have it excluded because we didn't look for him a year ago, 2 years ago, 2 months ago, 2 days ago. So it is highly prejudicial, and it violates Article 1, Section 29 due process of the people to assert that the people have failed to disclose in a timely manner the testimony of a witness. And we could argue this all day, because then I'd ask an instruction, the defense counsel just said, well, we found out 10 minutes, she had 10 minutes to prepare. Well, they had the discovery well before that. We've been arguing this for a couple of days. This is where we get down that slippery slope. This is an instruction that in most scenarios is improper, and in this one it's highly improper, specifically because there was no failure, and also because the court already opposed the issue, excluded us from producing this witness in our case in chief. Mr. Little says, well, that gave us a windfall. Well, that was the sanction they sought. That was the sanction that they got for what we believe an improper sanction, with all due respect. But nonetheless, this instruction is a road too far.
Okay. Submitted.
Your Honor, I just want to add one case, Henry Littlefield, which indicates that the obligation under 1054.1 doesn't just include information within the possession or control of the prosecution literally, but any information reasonably accessible to the prosecution. And again, I don't want to relitigate the discovery issue, but they were on notice as early as December 20th, and probably earlier. Mr. Little, who's counsel of record for both clients before I came to this case, says as recently as I think you said back this September of 2022, we were already making these requests. They said repeatedly there was not going to be a witness on value other than Mr. Jimenez, repeatedly to us. And we didn't find out until March 2nd, a few days before trial, that there would be another witness on value. I think this is a classic example of a discovery violation, a classic example of trial by ambush, and I think the jury is entitled to hear that our expert only had a very short amount of time to prepare for anything that Mr. Sutton was going to testify about.
Okay.
Your Honor, under Barrett v. Superior Court, in order for 1054 to apply, the material has to be in the possession of the prosecution team. The prosecution team does not include third parties, even people who represent alleged victims or alleged victims themselves. What's required is that we comply with 1054 and subsequent sections once we obtain that, and that comes to within the possession of the prosecution. In this particular instance, when this interview came into possession of the prosecution team, it was disclosed immediately. That's what the law requires. This instruction serves only to unfairly attack the prosecution in this unfair slant that the prosecution is somehow biased in this case, which seems to be a recurring theme. It should not be allowed.
And just, Your Honor, just to clarify, the problem I have with how this sort of went down is the prosecution was on notice that value was at issue a long time ago. And it reeks of unfairness for them to essentially sit on preparing their case until the last minute and then say, well, we didn't have it because we didn't ask. They didn't come into court saying, you know what, we're disclosing this late witness, we need more time. And that would actually confer another benefit to them. So I think ultimately this instruction is a fair price to pay for not looking at this until the Friday before trial and doing these things, because certainly had they followed the rules that we followed, our expert would have had more time to respond to what Mr. Sutton would have said. We would have been able to do that. And so I think this is a fair instruction and it's necessary.
Okay.
Thank you.
All right, thank you. The court's going to exclude 306 for this reason. If Mr. Sutton had been allowed to testify regarding economic value of the company in people's case in chief or even in rebuttal, okay, I think this would probably be an appropriate instruction to give, but Mr. Sutton was not allowed in their case in chief as well as in rebuttal to discuss to testify regarding economic value. For that reason, the court's going to believe this instruction does not apply and sanctions already been given, and so 306 is going to be excluded.
And we would just, I apologize if I don't know if this is the court's routine practice. We would just ask for any excluded instructions be kept for the purposes of the record on appeal.
Yes.
Thank you.
Okay. 332, expert witness. That would be granted. All right, 332 is expert witness testimony that very applicable and requested by both sides, so that would be provided. 333, opinion of lay witness. We do have opinion of lay witness testimony, and so that would be granted. 350, character evidence of the defendant, Alexandra Paul. That is appropriate. Let's see.
I think, Your Honor, on 350, the only difference between the prosecution and the defense is the defense instruction says, I think much more accurately with Ms. Zuniga's testimony, that Ms. Paul, and maybe I shouldn't be arguing this, but is an honest person with a desire to help other beings and alleviate their suffering, which I think is a fair vignette of her testimony, whereas the prosecution version just has the character trait as being honest.
Yeah, and I should add, since Ms. Paul is my client, the two character attributes we had Ms. Zuniga testify about were honesty and generosity. The fact that she very unlikely would have larcenous intent. So I think honesty is not the only character evidence that was presented. And honesty and generosity were both presented. And I like Mr. Little's characterization, but at a minimum, something beyond just honesty should be included in this instruction, Your Honor.
And Your Honor, the people changed the wording to, we believe appropriately, to say the character evidence was introduced to show she is an honest person. As written by the defense, it amounts to defense argument that this is who she is. When they talk about desire to help other beings and alleviate their suffering, that amounts to a defense argument. It doesn't fall into specific traits of character. So for those reasons, the trait of character is honesty that came out. And I'm not disputing, by the way, but we're not going to be disputing that Ms. Paul is a generally honest person. So there's no issue there. But when it boils down to defense argument, I think it's improperly worded.
Okay. Well, the character evidence that would be relevant in this case is honesty. All right, because she's testified, and obviously her credibility, veracity is at stake. And so that's the character evidence that is at issue here. So I'm going to go ahead and adopt people's finding and say Alexandra Paul is an honest person. Let's stay with that.
Your Honor, we asked no questions under 351 that would comport with that instruction, so that's why we left it out of our packet.
Submit it, Your Honor.
Okay.
And just noting our objection to the version of 350 for the record as well.
Okay, noted. Right, yeah, I didn't see any of that, so 351 is excluded. $360 statements, statements to an expert. Yes, I think that's relevant and requested by both sides. So can- 370 motive, requested by both sides. That'll be granted. All right, now the people has 400 aiding and abetting general principles.
Yes, Your Honor. The court has a sua sponte duty to instruct on aiding and abetting when there's a potential theory of the case. For the reasons we've stated under one of the previous instructions, we believe that aiding and abetting is a viable theory. We ask that both 400 and 401 be given.
And again, Your Honor, we are objecting because it creates a whole host of issues. We didn't have notice, and also it creates a huge potential unanimity issue. I think the court's instruction earlier, I think as part of 202, that Ms. Paul is being charged with stealing a chicken and Ms. Santurio is being charged with stealing a chicken is a fair summation of the charges in this case. And if we include an aiding and abetting theory, we're never going to know for purposes of sufficiency of the evidence what exactly they were convicted of as to which chicken.
And Your Honor, if it's a legal theory, it's not excluded because it can be confusing. And I don't believe it is confusing, but it being a valid legal theory, we ask it to be given.
Your Honor, I would just add that the people's proposed instructions just from a few days ago did not include an aiding and abetting instruction, so this is another example of the trial by ambush that we've had over the last few weeks. I think there is some case law suggesting an aiding and abetting instruction is appropriate in cases at a later stage in the trial proceeding, but there's also a statute, Penal Code 1009, that says effectively an amendment to an information or an indictment or complaint at this late stage is not appropriate. With that, I'll submit.
Yes, and also, Your Honor, I was going to add, if you look at the video, there's no evidence that they were aiding and abetting each other. One person took one chicken, and the other person took a different chicken. There's no evidence that they helped each other.
And no notice that this was a theory the prosecution was planning to present until literally the last 24 hours, or less, actually. And Far from it, we received instructions that did not include an aiding and abetting theory. The complaint does not allege aiding and abetting. There's been no notice of this until the last 24 hours from the time we received the instruction.
Well, counsel miscites California law. Penal Code 1009 does state that notice is required to amend an information complaint. But also, the Penal Code makes it very, very clear that a principal is somebody who directly acts or is an aider and abetter. That's a general principle underlying all criminal activities. In this particular case, the video has shown both defendants arriving in the same car, getting out of the same car at the same time, running up to the Foster Farms truck at the same time, opening the same door together, taking 2 chickens together, running back to the car together. There's statements on the video of Alicia got it, and then we see them get in the car and then they take off. And the defendant's own testimony talks about this being a plan, coming from out of the area to do this while the protest is going on. There is sufficient evidence that that they were aiding and abetting each other in the theft of these chickens. The notice argument is unfortunately missing the forest for the trees, because this is not something that needs to be noticed. This is just a general legal principle. Much like, as defense counsel argued in motions limiting, value of theft is a general legal principle that everybody should be aware of. So too is aiding and abetting. The fact that it wasn't in an earlier proposed set of instructions, well, trials are fluid. Sometimes after the evidence comes in, you realize that the evidence does in fact support the theory and it should be argued. So that's where we're at, and it is a sua sponte instruction.
You're right.
The only other thing I would add, Your Honor, is the fact that the defendants got into the same car might be relevant for aid and abetting purposes if one of the other or the other was driving, but neither person was driving. So.
Okay, all right, submit.
Yes, sir.
All right, yeah, this is a legal principle, general legal principle, and there are facts to infer that there was aiding and abetting, so that would be granted. 401, it's just an extension of 400, isn't it?
Yes, sir.
Okay. So I assume the defense would also have an objection to 401 as well, so
Same objection.
objections noted to 400 and 401.
Thank you, Your Honor.
The 401 is granted.
And same objection on behalf of Ms. Paul.
Yes.
Thank you.
Yeah, objection. Now, 1800, obviously this is the instruction for the crime. The only difference I see here is for the people's proposed instruction, there's a language on the agent. And for the defense, the agent language is taken out. But I think the agent language is appropriate, so the second element, a defendant took the property without the owner, and this here, the people left that out as well, but without the owners or owner's agent's consent. If we're gonna explain what agent means down below, then we need to include that on
I would
there.
agree. I'm sorry, I'll interrupt.
And then below paragraph, element 4, an agent is someone to whom the owner has given complete or partial authority and control over the owner's property. So I think that's appropriate. Given that Foster Farms is a corporation, we had a driver who supposedly was the agent of Foster Farms, who did not give authority or consent, did not give permission or consent.
Submitted,
So,
Your Honor.
That's submitted, Your Honor. We do have one more distinction. We asked the court to issue the instruction as drafted by CalPrim in terms of the last line. For petty theft, the property taken can be of any value, no matter how slight. Defense counsel has changed the wording of CalPrim. We'd ask it to mirror the actual CalPrim version.
And this is
Okay,
an
I do see
issue,
the difference there, yeah.
and this is an issue that we covered before trial, that we were going to say extrinsic value. So I thought that that issue had already been ruled on, that we were going to say extrinsic value instead of which is the language from the note, the commentary, rather than the instruction.
The case law says intrinsic value. The instruction does not say that.
It does, Your Honor. The CalPrim should not be modified unless necessary due to some specific change. Like we modified it for court recording versus court reporter because we didn't have a court reporter in this case. But in this instance where the CalPrim is directly contemplated and vetted an issue such as value and given specific wording, that wording should generally not be changed, and not in this case. It should be worded exactly as put in CalPrim. I think Adding the word intrinsic, now defense counsel, of course, is free to argue anything that comports with the law. They can argue intrinsic in their arguments. As far as the actual instruction, the way the drafters of CalCrim put it together, this was obviously something that was contemplated through a great deal of thought, through a great deal of people, and should not be changed.
Your Honor, if I could just add on behalf of Ms. Paul, I don't have objection to including the CalCrim bracketed instruction, but I do think that the commentary is relevant in this case because noting that the property can be of any value could include negative value, could include zero value. Technically any value, it's plausible that a jury could misinterpret that as meaning a negative value. And I think the actual commentary says the value has to be positive. There has to be some value, however slight. So I think the commentary is just clarifying. I would suggest we add the first sentence of the commentary to the instruction just to clarify to the jury. I would suspect some of the jurors may ask questions otherwise, and I think the answer we'll give them if they ask those instructions is from the commentary. So why not just give them the commentary now?
I think it's overcomplicating the issue. Any value, however slight, some value, however slight, that's what this law says.
Yeah.
I'm asking for a stick, Catherine.
Well, I think the way it's, the plain reading of that, it can be of any value, no matter how slight, that implies a positive value as opposed to a negative value.
Okay, Your Honor, I'm fine with that. As long as if the jury requests clarification, we answer that, then
Sure.
I'm fine with that. Yeah.
Sure, and I think the way it's actually proposed by the people, probably is more beneficial to the defense than putting intrinsic value in there, frankly.
Thank you, Your Honor.
Okay, so, granted, okay. Granted as proposed by the people. Okay, owner's opinion of value, that is, let's see.
Item
It's not
one,
being requested.
1801.
Okay, I'm sorry.
And Your Honor, we don't,
1801?
1801 should not be given in that, that should only be given with both grand theft and petty theft.
Oh,
Both
right,
grand theft
yes.
alone are charged.
Yes, 1801 by the defense.
Yeah, and I
Yeah, this is applicable to grand theft only.
Well, it says grand theft and petty theft.
And also the first language of the instruction says, actually I'm reading the wrong instruction.
Yeah, I would concur with Mr. Little. I think this instruction is appropriate. We previously briefed the court on this, and I'll just read again from People versus Simpson, where the appellate court indicated in instruction that the test of grand or petty theft is fair market value. I'm summarizing, but this was the instruction that the Court of Appeal expressly said was the appropriate instruction. It is the instruction left in 1801. 1801 does distinguish between grand theft and petty theft, but it also says very clearly, and this is a direct quote from that instruction, that the value of property is the fair market value of the property. And I think that's kind of the question at issue for the jury. So in light of the fact that the statute 44, People versus Simpson, which is the binding law of the state of California, and the various interpretive doctrines we cited about how value cannot be completely subjective, it has to be based on some fair market or monetary measure. I think this instruction is appropriate, and the jury is not going to get the correct statement of the law if they're not given this instruction. And I can cite People versus Simpson, and the exact instruction the court ruled was, again, the requested instruction should have been given, that the only test of grand or petty theft is fair market value.
And Your Honor, counsel hit it on the head. The test of grand or petty theft, the test of which one you have, is fair market value. The way it's worded, it assigns a greater meaning to the term value. The term value can apply to anything in a petty theft case. It doesn't have to have a specific fair market value. And that's the problem with this, is this 1801 should only be given if the issue before the jury is whether or not this has a significant value such that it rises to the level of grand theft. That's self-evident by the redactions defense did to the instruction itself, that that's the only reason it's intended for, and it serves only to confuse the issue for the jury to just add another statement about value.
Your Honor, I would just say, I don't know how it would confuse the jury if it's giving a more objective and specific measure of value that's defined by the statute and by relevant case law. So I don't think we have to have this as a separate instruction, but if it's not included as a separate instruction, I would request that it be added to the 1800 instruction, because again, the statute is quite clear that the test of value is fair market value. The case law is quite clear. People versus Simpson says the instruction that petty value requires fair market value is appropriate. And again, various canons of statutory construction. Under the prosecution's theory, where value is not linked to any particular objective metric, someone could be pursued for a theft for taking a piece of lint, taking a piece of garbage, who knows? It's completely dependent on the arbitrary subjective valuation of another individual. And that can't be the case. That's a basic violation of due process.
Matter of fact, that's exactly what the law says, is that it could be so much as a wrapper or a peppercorn, is that when value, a specific value is not at issue, then we're not talking about in the same context as counsel's talking about here. Counsel's confusing issues in the Simpsons case. He's talking about the test of grand or petty theft versus the value for petty theft, which we've already discussed in 1800. That disputes me.
Okay. All right, submit.
Submitted.
Okay, court agrees that 1801 is not applicable, it's applicable to grand theft only, so 1801 is excluded. $1860.
So, Your Honor, we did not include that in our packet. We know that there was testimony.
I think we included it.
We did? Okay, I must have shuffled it around.
Yeah.
That's a questionable one. I will defer to the court. There was statements as to it having value. I think 1860 is generally reserved for when the opinions is of a specific value, but with that said, I have no objection to it being given. I'll defer to the court though if it's appropriate.
Well, Your Honor, I think that we included this instruction in anticipation that Mr. Sutton would be giving more detailed rebuttal testimony than I understand he actually gave. I understand that the court did not permit him, because the door had not been opened, to give specific value testimony when he testified on rebuttal. So I don't think we need 1860.
I would actually disagree.
Oh.
Having heard the testimony, he claimed very clearly and explicitly that the chickens at issue had some value. And I think that he's an owner or an agent of an owner, and the instruction is appropriate. I don't know, co-counsel,
Your Honor, I
Mr.
think we-
Fairway concurs, having heard the testimony, but,
I'm a split vote here.
okay, split vote.
well, with defense request, I think it's to respond to at this point. I would submit.
The court of grant 1860, I did hear from Mr. Sutton as well. The jury can determine what they believe.
It's like saying the parent I want to go with.
Yeah, the weight of his testimony, but he did opine regarding value.
Submitted, Your Honor.
That's fine.
Next would be 1863.
Yeah, defense 1863, claim of right. Defense regarding claim of right.
Yes, Your Honor. We believe it's supported by the evidence that's been presented. The claim of right obviously is the right to rescue, and based on the defendant's knowledge of the likely state of the chickens involved and the legal opinion. So this instruction is supported by the facts, and it's a defense instruction. I think the court is obligated to give any defense instruction that's supported by substantial evidence such as this one.
Your Honor, just to sort of supplement, this is all principles taken from our motion to limb, and the court held that issue
Right.
under advisement, and if the court wants, I can hit the citations, but just.
Well, let me just try to understand. Claim of right is where somebody claims that I have some sort of title or ownership right to that property. And the title, the ownership, possession of it may be in dispute, but I claim to have it. This is not the situation. They claim they may have a right to rescue the animal, but they're not claiming that they own that animal or somehow had a title ownership interest in the animal. Am I mistaken about this defense, Mr. Elwell, Mr. Colby?
Your Honor, in their testimony, the defendants agreed that, stated, they knew the truck belonged to Foster Farms, chickens on those trucks belonged to Foster Farms, and it was heading to a Foster Farm facility. They did not specify that they believed in any form that they owned the property, and I'm going to take a guess that defense will argue that there's a claim of abandonment, and because their testimony due to the chickens being treated as garbage. However, again, they specified that they knew these chickens were headed to a foster farm facility to be used. There was no argument that these chickens had been owned by the defendants or that foster farms had discarded these chickens.
Well-
And so that there is no claim of right even under that theory.
And excluding those defense does not prevent you from, does not forbid you from claiming right to rescue. That's under mistake of defense, mistake of law defense.
Yeah, and I think they're similar. I think the interpretation of claim of right is, I think, narrower than what the case law has said. I'm citing from Tafunga, 987 Pacific 2nd, 168. And quote, the claim of right defense provided the defendant's good faith belief, even if mistakenly held, that he has a right or claim to the property he takes from another and negates the felonious intent necessary for conviction of theft or robbery. And I would further go on to quote Tafunga, if I'm saying it correctly, I apologize. The trial court should not measure its substantiality of the evidence by weighing the credibility of the witnesses. Doubts as to the sufficiency of the evidence to warrant instructions should be resolved in the favor of the accused. And I would also note, I mean, I think if we're reading an ambiguity where we're arguing about how broadly the statute extends, then the court should apply the rule of lenity and resolve the ambiguity in favor of the defense. And I would submit beyond that.
Okay.
Aside from asserting we make this request pursuant to Ms. Santurio's due process rights protected under the state and federal constitutions.
All right, submitted.
Yes, I'll just join.
Okay, the court does not believe that the 1863 is applicable for this reason. First, as I understand it, the claim of right again is applied to a situation where the defendant claims some kind of ownership or title interest into the property. And secondly, in the facts of this case, the court does not recall hearing any evidence where the defendants claimed some kind of ownership or proprietary interest, ownership interest in the two chickens at issue, so that it's excluded. Okay. Now, to take a law as a defense, the people did not request it, the defense requested it, but it's, we've argued this ad nauseum point, have motions eliminate. Anything else to be argued?
Other than I stand by my arguments, no more.
Okay, all right.
I think certainly the evidence supports the leaving of this instruction.
All right.
My version of the people's proposed instruction actually does include it, so I don't know if it was inadvertent, but.
No, it includes it because of the court's indicated
I see.
ruling. We're
Oh,
still
okay.
objecting to it.
People did include that, yes, that's true.
Right, the fact it's included on our packet is only because the court had previously indicated it would likely receive it. We're still objecting, we still believe that mistake of law, and actually here's an interesting point, if I can bring up something else. Mistake of law does not apply to a general intent crime. Now, these are specific intent crimes.
Sure.
So let's think about that in context of their argument for mistake of law here. They are arguing the mistake of law is that they had the affirmative defense of necessity. Now, they could have an affirmative defense of necessity, in theory, to a general intent crime, and mistake of law wouldn't be given because that's a general intent crime. And it highlights our objection that mistake of law should only be given when that mistake can negate the specific intent for the crime, not an affirmative defense. So I guess that's another illustrative way to highlight my objection. So I know I said I had nothing further, but that's all I got.
All right, court's going to grant it.
Your Honor, with respect to 3411, the only editing type comment I have is in the last paragraph of the defense version, it refers erroneously to the defendant. I had tried to replace that everywhere with a defendant, since obviously we have two defendants here. So I would request that it just be changed in the third paragraph of 3411, where it says, if you have a reason about whether the defendant, it should say a defendant.
Okay,
Thank you.
no objection. All right, judge's comments on the evidence, okay, that'll be granted.
Although there is a difference between the defense and the prosecution, the defense's version also lists the California Constitution and penal codes in their title of the instruction,
Yeah, I can
while
see that.
ours does not.
Okay.
Submitted.
I'm just gonna strike out the code sections there, in the bracketed language. Okay, and then just the next is 3550, which is standard Happy Hen.
There is one difference that may not make a difference
Yeah, go
in these
ahead.
instructions. The defense, I think our instruction just says, do not communicate using Facebook during your deliberations, and the prosecution's version says any social media.
Yeah,
Okay.
that's typically what I do with Facebook, YouTube, Instagram. I could list them all, but it would add another page, so I just say social media.
That's fine.
That's fine.
Yeah, well, I would, yeah, say social media as well, just make sure we cover every basis.
No, that's just a
All right,
justification.
substitution of alternate juror. Typically, I would leave that out unless we need to
Yeah, Sean.
do a substitution.
Yeah. We submitted it just,
Yeah,
we understand it's an if and when
Okay.
situation.
so that's,
As is 3576.
yeah. And 3577, same thing, excluded unless necessary.
3577 would still apply since, even if we didn't sub in any alternate jurors. Sorry.
Oh, right, I think 37 would be given because, yeah, I would give 3577
So,
until they are, it's appropriate until they are discharged. Okay, and then final discharge to jury, okay?
And Your Honor, one thing, I've received proposed verdict forms. I know that the court's rules and procedures require one verdict form for guilty, one for not guilty, instead of both on one form.
Right,
I will prepare an email forms to counsel, so get back to my office, it'll take 5 minutes. Conform forms.
right, the only thing, the verdict form from Mr. Little I see is, I don't know, it'd just be confusing to jury because you put all the other code sections, 484, 490, other things there. I think it's prefer to keep it for simple. If you want to do 484A, that's fine.
Yes, Your Honor, I'll email it to counsel, and counsel, once we settle that, I'll email it to the court.
Okay,
Very well.
all right. Anything else?
Judge, I think there are maybe 2 motions in limb with respect to closing. We can either address this
Okay.
afternoon or tomorrow morning.
Let's address it. I'm not sure if we have time to move.
Sure. And this might just me being a little neurotic, but certainly when the prosecution had argued against the mistake of law defense, a common refrain was anyone could go to any old attorney and get a letter, and that's sort of an unfair public policy argument to argue in front of the jury. That's a fine argument to go to the legislature or arguing policy issues in front of a judge, but I would ask that the court or the prosecution not to make such public policy arguments, because that's essentially saying, jurors, if you apply this law, even if you think it's warranted, think of the consequences of what could happen. I don't think that's an appropriate argument. I'm not sure the prosecution's going to argue that, but I would rather just address it beforehand rather than try jumping up in the middle of someone's closing. So I think that's my first motion with respect to closing arguments.
Okay, Mr. Atwell, Mr. Cohen.
Your Honor, if I can parse that out into 2 bits. The argument of, look what could happen in the future is problematic argument that we don't intend to make. However, especially in this particular case, we have a letter written in response to this activist group. And then we have another letter written complaining about foster farms by this activist group. It is a completely fair argument, if I choose to do so, to call that self-serving and to explain that that has less weight in terms of a reasonable and good faith belief because of the self-serving nature. I think that's entirely appropriate. I would agree with counsel that if I were to, and I have no intention of doing this, start talking about threats of future harm, of in the future anybody can do this, that would be a bridge too far. But that's my position.
I think-
I take that to
I
consider.
understand the distinction, and
Right. Yeah, I
Okay.
think, yeah, our concern isn't that, any fact-based arguments, is any argument that would derogate the defense or the concept of mistake of law.
It's slippery slope argument.
yeah.
Okay.
And the second issue is just sort of clarifying the mistake of law as a defense. Because I want to cite People versus Weinberg, that's 125 Cal App 3rd 127, and it goes on saying, generally mistake of law, the principle is it's not a defense to general intent crimes. However, the principle that it's not a defense has, and I'm starting to quote, no application with respect to crimes requiring a specific intent. It's been recognized in California since the turn of the century that ignorance or mistake of law can negate the existence of a specific intent, and that it is a valid defense to a charge of theft that the accused honestly believed that he had a right to take the subject property, even if such belief was based on a misconception of the law, end quote. So the reason I'm really highlighting this is, in Weinberg, the court didn't grant the mistake of law because it sort of held as a matter of law there was no good faith belief to even invoke that. We're certainly past that point. But as a general principle, I read Weinberg as precedential opinion that sort of mistake of law is a complete defense to the intent required for larceny. And where I'm sort of concerned is certainly we can parse out the jury instructions and try to get very technical, but I think the state of the law is it's a complete defense. And I just want to make that clear because, again, I think if the prosecution were to argue that even if they had, such a good faith belief their conduct was lawful and they had the right to take the subject property, that there's some other sort of nuanced specific intent that it doesn't touch, that's not the state of the law. That's not what Weinberg requires. And so, to the extent, I think in the alternative we could have an instruction based on Weinberg, but I think the state of the law is it's a complete defense.
Otherwise, it wouldn't be a affirmative defense.
Well,
Right.
it's actually, Your Honor, it is a complete defense, but not in the way counsel recited it. It's a complete defense in that if there is a mistake of law that is honest and in good faith, and that mistake of law negates the specific intent required for the crime, it is a complete defense.
Right.
So it's very important that that is the state of the law, that the mistake of law has to negate the specific intent for the crime. Now, what counsel, I think, is trying to expand that into is that any mistake of law can, even if it's not as to the specific intent for the crime, can somehow invalidate the whole crime. And that's not the state of the law. So as written by Calcrim, the mistake of law defense is appropriately written, stating that a defendant is not guilty of the crime if they make an honest or good faith mistake about the law, if that mistake shows they did not have the specific intent required for the crime.
Right.
And I'm just quoting appellate decisions that discuss the state of the law. I can continue. If a
Well, before you quote though, is Mr. Cody stating your position correctly, or is that what you're trying to argue? Any mistake of law is a defense?
Your Honor,
You're not making that argument, are you?
the position I'm arguing is if a defendant is operating under a honest or good faith belief that their conduct, I'll repeat. If a defendant is operating under an honest or good faith belief that he or she had the right to take the subject property, even if such belief was based on a misconception of law, that negates the requisite criminal intent required for larceny. And I further sort of back that statement up, and a lot of that language was taken from Weinberg. But if a person honestly believes that he or she has a right to the property, even if that belief is mistaken or unreasonable, such belief is a defense to robbery. And that's from the notes to mistake of law, and that's People v. Butler, 65 Cal 2nd, 569. And I think the thing that really buttons up this basic principle is People v. Richards, which is 18 Cal App 5th 549. And Richards discusses, granted, Richards is a mistake of fact context, but the same principle really applies. In such case, the mistaken belief, quote, must relate to a set of circumstances which, existent or true, would make the act charged an innocent act. Such a belief precludes the finding of wrongful intent that is generally required to establish the mens rea for a criminal offense. Of course, Richards is talking about a mistake of fact, but I think they're rather identical in terms of the legal analysis. And I'm just simply asking the court to take the rules that are set out in Weinberg by higher appellate courts and apply that as the law. And because I think the law as it is now is a little technical and confusing. And I just want to make sure that clarification, based on court precedent that this court is bound by, is followed.
And Your Honor, if I may respond, People versus Koenig, 2020, 58 Cal App 5th, 771 and 809, says that defense is limited to crimes in which specific intent or mental state is negated by the mistake. And then further, there's People versus Ursau, which says the same principle, URZICEEANU, and I probably will never pronounce that right. 2005 case, 132 Cal App 4th, 747 at 774 to 780. It is limited to crimes in which specific intent or mental state is negated by the mistake. And that's very clear. That actually is the second case cited in the bench notes. It's so prominent, Calprim saw it to cite that in the bench notes. So for those reasons, the instruction, again, objecting in general terms to the law for those reasons as well, but understanding the court's giving this instruction, it should not be modified. The people should not be limited to an argument that any mistake of law can negate the crime when it has to go to the specific intent.
I'm hearing the same thing. I don't know if I'm just, maybe it's too late in the day and I'm not hearing it.
I might be saying the same thing.
And I'm going back to 3411, mistake of law defense. A defendant is not guilty of petty theft if she made an honest or good faith mistake about the law, if that mistake shows that she did not have the specific intent required for the petty theft. So I just would stick with that.
Thank you.
Okay.
Your Honor, if I might, just to clarify the ruling on public policy arguments, I'm aware that counsel is not entitled to share their personal beliefs, and there are certain arguments that are prejudicial or inflammatory, golden rule arguments, send a message arguments. I'm not clear on any law, and I apologize for disagreeing with co-counsel on this, that prohibits talking about the consequences of a particular ruling one way or the other, as long as it's not prejudicial. And I was planning to talk about the consequences of various rulings and the consequences of animal cruelty laws being violated, and I think that's typical in a closing argument. We talk about what does a verdict mean in this case? If you render a verdict of not guilty, what does that mean? If you render a verdict of guilty, what does that mean? And as long as it's not prejudicial and inflammatory, I think those arguments are okay and within the bounds of the law. And I don't know of any statute or case law that suggests otherwise. I just want to clarify because I don't want to make a closing argument that is going to go against the court's ruling.
We should bring that up because that will be objectionable. They are presumptively and per se inflammatory to argue that because of the jury's verdict, some particular outcome may or may not occur, just as I can't get before a jury, rightfully so, in a gang homicide case and say, if you let this defendant go, people will die. I can't say that. Defense counsel can't get up and say that if you don't acquit my clients, animals will die. And I understand that this is the position that they're advocating for, but in terms of this court, it is presumptively invalid to argue the effects of a verdict. Matter of fact, it does violate the issues about discussing punishment. It violates the issues of providing inflammatory argument to the jury. It's an improper argument. We would strenuously object to any argument about what the result of a verdict would be.
Your Honor, I don't understand how this intersects with punishment at all if you're just talking about the consequences of a verdict, one way or the other. That doesn't relate to punishment whatsoever. And secondarily, inflammatory, I think it depends. I agree that we cannot make inflammatory arguments, and there's case law on this, but that depends on how the argument is made. If someone's getting up here and saying, if you rule against us, these MFs are going to abuse and torture animals, that's one thing. If you say, on the other hand, that there are policy consequences to lack enforcement of animal cruelty laws, I think that's fair game in a closing argument, as long as it's not inflammatory, and that's a standard. So I don't think there's a general rule that using the common sense conscience of a jury, of a community, in fact, I think that's what the Supreme Court ages ago ruled on Duncan versus Louisiana. The entire point we have the jury system is because the conscience of the community is supposed to be interjected into our criminal justice system. And I just want to understand the boundaries, because while there are cases that rule, a prosecutor, for example, can't say, you know, someone else is going to get murdered, those usually involve defendants' constitutional rights that aren't implicated in a case where a defendant is saying there are policy consequences, for example, to allowing animal cruelty to continue unabated.
Your Honor, California Constitution, Article 1, Section 29 says that people have due process, just as the defendant does. To say that there's some unbalanced standard here where they have more due process than we do is wholly unfair. Once again, to argue about consequences is not arguing about guilt or innocence, and is not an argument that pertains to what the verdict should be. It's an argument that pertains to what the consequences of a particular verdict would be, which goes well beyond any permissible argument.
Okay. All right, well, yeah, the general, I don't know what you're going to say, but if the court will indicate that that would be improper argument, because it cuts pretty close to the issue of punishment. Punishment is the purview, is the jurisdiction of the court, not the jury, and to invoke the jury to speculate to go into that area, that be, to invite the jury to go into that area would be entirely inappropriate. So, yeah, you're not to go.
So just to be clear on your Honor's ruling, speaking about common sense and the conscience of the jury is appropriate as long as we don't talk about punishment in any way, or invoke punishment.
Well, I would disagree. If basically saying that if you follow the law, you won't like the social consequences. That's what I'm hearing, and that's a problem.
Right, and if you don't do this, you don't take appropriate, you don't render an appropriate verdict. This is what's going to happen out there in the community. What flows from that, I think that's quite inappropriate. So that would be a decision of the court. You're not to go there. Okay.
Thank you, Your Honor.
All right. Anything else?
I have nothing, Your Honor.
Okay.
Your Honor, everyone gets to argue that.
Not everybody. You're going to have to choose between yourself and Mr. Carraway.
Fight over it.
Okay.
Place your bets.
All right.
He drew the long straw.
Okay. All right.
Judge, are there time limits on closings?
Well, let's see. We have
I can't be here in the
between.
afternoon tomorrow, so that's the first one. Sorry.
Yeah. Hopefully we'll start by 10:30 after I read the instructions, and we have an hour and a half before noon. You know, if we need to come back in the afternoon, we certainly can come back in the afternoon to complete closing argument. But I don't generally put a timeline on closing arguments, but I hope not to go to Friday.
I don't anticipate closing arguments being all that lengthy on our end. Hour and a half seems more than enough, but if we do happen to spill over, that's the problem I addressed with the court earlier. I'm unavailable tomorrow afternoon, so that's the issue. Now,
I just wasn't sure if I was going to get cut off 10 minutes into it. I've had that problem.
No, I'm not going to impose a time limit.
I'm not going
I
now.
don't do that.
I swear.
And once closing argument is conducted in the afternoon, Mr. Atwell will be here for other matters as they approach, but I will not be really at the
Well, but I will also indicate to you that, you know, if we're not done by 12:30, and let's say the defense completes theirs by 12, I'm saying not 12:30, at 12, and you want a rebuttal argument, and you're not here in the afternoon, if somebody's giving, Mr. Elwell's gonna give it, or you're gonna forfeit that, so.
Well, Your Honor, I thought we discussed this earlier, and I can discuss it at bench if you'd like about the reasons for.
I understand, but I can't control, given two defendants, I can't control how much time they're gonna take in their closing arguments. I'm saying is, certainly you're gonna have an opportunity to do your opening closing, your initial closing. But in terms of rebuttal, I can't guarantee you that we're gonna complete that by noon.
And if the court's going to allow us to stay until 12:30, I mean, I know how long my closing is, so I think we're good on time.
Okay.
Yeah.
All right, and if we need to go So 12:30, I think the jury will
Well,
understand.
we can cross that bridge when we get there, but if I may approach after we're done here with counsel just briefly.
Okay. All right.